All right, students, let us continue our discussion. So, up till now, we have discussed what is an LLP and when is LLP suitable as a form of business organization for you. Then we discussed few definitions which will help us to understand the act. In today's session, we are going to cover the characteristics of LLP. Ideally, in my notes, I have covered partners and designated partners, but I think we will discuss it later because since we are discussing everything about LLP. So I want to cover the basic points first. We have discussed what is LLP. Then we studied the definitions of LLP. Now let us discuss the characteristics of LLP, the advantages. And after that, we will pick up each element like who is a partner, who can be a designated partner, etc. So moving slightly ahead, let us discuss characteristics of LLP. Students, I had promised you that I will make you learn the entire act in the lecture itself. So in order to make you learn, I have designed few handwritten notes for you. In my previous lecture, I had already prepared the notes we discussed and you made a note of it in your notebook. This time you will write along with me. Now the advantage is that as you write, you will be able to learn those provisions. They are very simple provisions. Okay. And if a question is asked, then you will be able to quote all the 18 points seamlessly. We are going to make a note of each and every characteristics. I will give you extra points also. I will break it into provisions that you can learn. Okay, the manner in which you can learn the provisions. So students, let's discuss characteristics of LLP. I will need a notebook. I want you to give the heading in your notebook as characteristics of LLP. And you can write along with me. I'm going to go slow. I think it'll be manageable. It's not very complicated. Give the heading as characteristics of LLP. A theory question of, I think, weightage around 5 to 7 marks. Okay, weightage of 5 to 7 marks can be asked. They may ask you to list all the characteristics and explain maybe 5 or 6, or they will say just explain the characteristics. Depending on the marks, you will write the characteristics. If the question is for 12 for 6 marks, then write 12 characteristics. 5 marks, then write 10 characteristics. Why double? Because the characteristics are explained in just a couple of sentences. So I don't think there's a lot of content to write. You will have to write more head points. Okay, so you will have to cover more points. The content is 1 or 2 sentences only. So it is manageable. You will be able to write 12 points comfortably. You need to remember the head points. The other provisions can be written in your own words. But I'm very sure after writing the notes, you will be able to convert this note into sentence form easily in the exam. So let's get started. The first characteristic of LLP is that LLP is a body corporate. Now, we had in my earlier session discussed the definition of body corporate. So, what is a body corporate? It means a company formed under Section 2, Clause 20 of the Companies Act. Yes, it is a company which is incorporated under the Companies Act. It means a company incorporated in India, outside India, LLP incorporated in India, outside India. Body corporate. It consists of two words. Corporate, it means that it has to be formed, it has to be incorporated in the act. Now, since we are discussing the LLP Act, all my discussion will be around the LLP Act. So it is formed, it is incorporated under the LLP Act. Body, because it is clothed with legal personality. From this, we conclude that body corporate means that LLP is a separate person in the eyes of law. It also has perpetual succession. Let us write, let us break it down, and then I will teach you how each word is connected to the other. Body corporate. Why is LLP a body corporate? Because it has to be formed and incorporated under the LLP Act. So it is formed, it is incorporated under the LLP Act. It does not take birth like a natural person. You have to form it, you have to incorporate it. Yes, so that is why it is a corporate body. It doesn't take birth like a natural person, it's an artificial person. Because it's an artificial person and you have to form it through the operation of law, it will also never die a natural death. you will have to wind it up by following the provisions of law. So can I say that through these points we come to a conclusion that it's a separate legal state, separate legal entity. It has perpetual succession because it does not die a natural death. It will go on continuing till it is wound up. Yes. So it is formed, it is incorporated as per section 3 of LLP Act. Now, do we need to remember section 3? Yes, you need to memorize that section 3 says LLP is a separate legal person in the eyes of law. Separate legal person means it is capable of contracting in its own name, it can buy assets, it can incur liabilities. It is a separate person in the eyes of law. It's a person, but is it a natural person? No, it's an artificial person. Because it's an artificial person, it doesn't die a natural death. It's not like living people, natural persons. Doesn't die a natural death. It continues to exist till it is wound up. Because it continues to exist, this is perpetual succession. See how I am connecting each word with the next sentence. Yes, I learned only one sentence. It is formed and incorporated under this act. This act, it means the LLP Act, section 3 says that LLP is a separate person in the eyes of law. Person, it means it's an artificial person. It does not take birth like a natural person. It doesn't even die a natural death. It continues till it is wound up. It means it has perpetual succession. Is it clear? You can also include one more provision here. Perpetual succession means that LLP is not affected by any change in the members. So members may die, members may retire, members may become insane, insolvent. The company is not affected. But is this in case of partnership? In case of partnership, the firm is dissolved or the partnership is dissolved depending on the situation. But there is dissolution. Yes. Over here, any change in the partners will not affect the existence. This is separate legal status. It is a separate person in the eyes of law. Okay. So perpetual succession, see, all the points are interconnected. So it is a separate, because yes, last lecture, do you remember I had mentioned that body corporate to a layman means that it has a separate legal status and it has perpetual succession. That is for a layman. See, we are including those points itself. Okay, we are including those points in our answer. Perpetual succession means that LLP is not affected by any change in the partners. That is death, insolvency, insanity, retirement, etc. So it is not affected by any change. It has its own existence, it has its own rights, it has its own liabilities. It is a separate person. So LLP is a body corporate. I hope you mentioned all this in your notebook. Yes. Let us continue our discussion. The second feature, the second characteristic is formation. Again, formation is very simple as compared to a company. The incorporation is very simple as compared to a company. The documentations are also less as compared to a company. Only two persons required to form LLP. Now, this is very similar to your partnership. So, only two persons required. These two persons must be competent to contract. They must be of sound mind. All that we are going to discuss when we come to the discussion of partners, designated partners. Now, how do these people become the partners of LLP? It is through LLP agreement. So, we agree to do business together. This agreement is very similar to the memorandum of association of the company. This agreement is in writing and it is filed with ROC at the time of incorporation. So, for formation, we require only two persons. Now, these persons are partners. From these partners only, we need at least two designators. So, if you have only two, sorry, at least 2%, formation is at least two persons. Only means, yeah, we need only two persons. That's an advantage. Only two persons required. In public company, you need seven. Here, you need only two. But yes, if I say only two, it doesn't mean that you cannot have three or four. So it is better to write at least two persons. And these persons are known as partners. Out of these partners, you will have two designated partners. Okay, that we will write later, not now. Now, these persons enter into a partnership agreement. Now, this agreement must be in writing and it will be filed with ROC at the time of incorporation. Now we have already formed an LLP. So what is the purpose? What is the business for which we have incorporated LLP? So let us discuss something about business. Now this business will include every trade, profession, etc. The word business gives us an impression that it should be a profitable one. It should be with the aim of earning profit. Non-profit or charitable or you can say non-economic purpose will not form an LLP. So LLP can be formed to do business with the intention of earning profit, okay? With the aim of earning profit. So can I say that LLP cannot be incorporated for charitable or non economic purpose? It cannot be incorporated for charitable or non-economic means my aim is not to earn profit. So you can form LLP only if you are carrying out a business with the intention of earning profit. See, this is a characteristic of partnership also. In case of partnership, we had studied that there must be a business. No business, no partnership. And that business must be with the intention of earning profit. See, only when you earn profit, you will share it. Yes. So same logic applies here also. LLP is nothing but a combination of partnership and company form of business. So it will have features of a partnership business. Another feature or another point that you can write over here is that business must be lawful. Lawful means it must be legal. You can form a business only for carrying out lawful objects. I'll give you an example now. You tell me whether it can do business in LLP or not. X, Y, Z, P, Q, R. They have started an activity of buying books, second-hand books, and then they are giving it at a very nominal profit to the underprivileged people or needy students. So let's say, for example, they bought books at 100 rupees. They will give it to them for 120 rupees. Sometimes they don't even charge money. Ma'am, why are they earning at 20 rupees? Because there is some cost involved. No, they need to survive also. And they are working. It means they need to run their homes also. So just 20 rupees they are adding and they are giving it to needy students. Will this be a business, or can I ask you in this manner that can they do this activity in LLP? It is not possible. They cannot form LLP for carrying out. This is actually a non-profit organization. It is an association for non-profit activities. So it's an NPO. You cannot do business. You can't do it in either partnership or LLP, because in partnership also it requires that you should carry on business with the aim of earning profit. So if your aim is not to earn profit, then you cannot form LLP. The next characteristics that we will discuss is perpetual succession. See, we are connecting all the points so beautifully. It is a body corporate. It's an artificial person. These are all the characteristics which we are going to discuss. How to form, for what purpose can you incorporate. So these are all related points. You will be able to learn them very easily. Perpetual succession. An LLP continues to exist till it is wound up. See, it comes into existence by operation of law. It can cease to exist also by operation of law. It is not affected by death, insolvency, insanity, retirement of partners. So you can write continues to exist till it is wound up. LLP is an artificial person. It doesn't die a natural death. It, in other words, it continues to exist till it is wound up. LLP is not affected by death, insolvency, insanity, retirement of partner. See, you may have to communicate all this to ROC, but will the LLP's status change? No, it continues till it is wound up. So that is nothing but perpetual succession. Let us now proceed to the next characteristic, which is separate legal entity. Yes, it is a person separate and distinct from the partners. LLP can own its own assets. They can purchase assets in their own name. They can have liabilities in their own name. Creditors of LLP are creditors of LLP and not of the partners. Now, when the partners give their capital contribution, okay, when the partners give capital contribution to the LLP, that money now belongs to the LLP. LLP used that money to buy assets. My question is, will these assets be considered as assets of LLP or assets of partner? See, they are purchased using the partner's money. So when the LLP uses that money to buy assets, will these assets be considered as asset of LLP or assets of partner? If you said, ma'am, they will be considered as asset of LLP, then your answer is correct. See, once the money is given to the LLP, that money belongs to the LLP. Now, LLP is free to use it the way it likes. Of course, they will use it for the objects of the LLP, but you cannot tell them that this asset was purchased using my money. Now, this asset is mine. Partner, once you give money to the LLP, that money belongs to the LLP. They can use it to buy any assets. Now, these assets will be considered as asset of LLP. LLP is a body corporate. We studied earlier that body corporate means it has its own separate legal status. It has perpetual succession. So, body corporate indicates that it is a separate person in the eyes of law, capable of contracting in its own name. Own name means name of LLP. So LLP is capable of contracting in its own name. Whatever assets are purchased, those assets belong to LLP, not partners. Liability is also of LLP, not partners. Creditors of LLP are creditors of LLP only. You can continue writing. It is capable of contracting in its own name. Holding property means assets. Holding property, that is assets, in its own name. Assets belong to LLP, not partners. The liabilities are of the LLP, not partners. Creditors of LLP are creditors of LLP only, not of partners. So creditors, they will hold the LLP liable. They cannot recover anything from the partner. Partner has limited liability. Partner is liable only to the extent of his share in the contribution. Whatever capital he contributes, I will not give more than this. So see how the next point is connected. Limited liability. Okay, now partner of an LLP will be liable only to the extent of his share in the contribution or whatever he has agreed to contribute. He will not be liable for any other amount. So partner, you can write down, partner is liable only to the extent of his agreed contribution. Now, in case of partnership firm, liability is joint, several, unlimited. I am liable not only for my share, but for share of other partner also. But for act of other partner, that will be better. So in this case, if I say in traditional partnership, okay, in traditional partnership, the liability is joint, several, unlimited. Joint means we are jointly liable. Several means we are individually liable. So I am liable not only for my act, but also for the act of other partners. There was mutual agency. Yes. In this case, there was mutual agency. What is mutual agency? Now, X, Y, Z, they were partners. Z borrowed 10,000 rupees from A for the firm only. But if X is not able to pay, can A recover from Y and Z? Yes. So in this case, X as an agent, he can bind Y and Z by his acts. Now Y and Z, they are liable not only for their own acts, okay, liable for own acts, but they are also liable for acts of other partners. But that is not the case of LLP. In LLP, there is no mutual agreement. So there is no mutual agency. I am liable only for my act. I am not liable for any individual or unauthorized act of the other partners. And what about authorized? See, for authorized act of partner, LLP is liable. Now, in LLP, there is no mutual agency. Ma'am, what is the meaning of mutual agency? Mutual agency means that I am, as a partner, agent of LLP. I'm not agent of the other partners. See, over here, X was acting as agent of the firm as well as agent of the other partners. But in case of LLP, partner is agent of LLP, not other partners. Other partners are not liable for acts of each other. Liability of the partner is limited to their extent of capital contribution. So this is the reason why we go for limited liability. Why is liability limited? See, you should know the logic. Why is it limited? because there is no mutual agency. I am agent of the LLP. I am not the agent of other partners. Okay. So because we are not agent of the other partners, we are liable only to the extent of our capital contribution. We are not liable for their acts. Okay. Now, to what extent, contribution. Let us discuss something about contribution. Now, this contribution may be comprising of tangible assets or intangible assets or both. Tangible means you can see, you can feel. It may be in the form of cash, goods, car, etc. Intangibles you cannot see, you cannot feel it, like goodwill, patent, trademark, copyright, or you may contribute both. Okay, tangible as well as intangible. Do you remember we had discussed in the first lecture that limited liability is one of the main reasons for converting a traditional partnership into LLP? Do you remember I had mentioned that many audit firms have now converted their traditional partnership firms into LLP? Reason is XYZ, they are three partners. If X is accused of some misconduct, okay, he is accused of misconduct, so X and Y, they are also liable. If Z is not able to pay, let's say now the misconduct is holding him liable for 1 crore rupees of penalty. If he is not able to pay, other partners will be liable. So that would happen in case of traditional partnership. Why should we bear the liability of somebody else's misconduct? That is why you will see that many of these audit firms have now converted into LLP. Do you remember the schedule which gives us the procedure for conversion? Schedule 2. Yes, Schedule 2, it provides for conversion of a partnership firm into LLP. So LLP is actually a very good avenue for professionals who want to, do some organized form of business. All right. So that was limited liability. Let us now write. I hope you are taking down notes along with me. Yes. Let us now go to, which number was it? Sixth. Okay. Let us now discuss the next characteristic, artificial legal person. It's an artificial person because it does not take birth like a natural person. It's an artificial person. Why artificial? Because it does not take birth like a natural person. You have to form it, you have to create it through the legal process. But it is a legal person. What is legal? It means it is capable of contracting. Law recognizes it to be a separate person. Okay, capable of contracting. It is a separate legal entity. Okay, it is legal. We recognize it as a separate person in the eyes of law. So why is it artificial? Because it does not take birth like a natural person, but it is legal. We recognize it as a person separate from the partners. It is capable of contracting. It is clothed with all the rights of an individual. Let us also write one more understanding of it. It is artificial because as it is created by the legal process and clothed with all rights of an individual. So it can perform all the acts that an individual can. So LLP can, okay? Let us divide this as to what LLP can do and what LLP cannot do. So because we recognize it as an individual, so it can do all the acts like a natural person, living person like you and me. It can perform all acts as a natural person. So it can do whatever a living person is doing. But see, I am writing that it can do all acts. However, LLP cannot. Okay. Now, I agree that it can do everything like a natural person. However, can it get married? No. See, natural person can get married, but can this LLP get married? No, no. See, although it can perform all acts like a natural person, but it cannot marry. If it cannot marry, it cannot be divorced. Very logical. It cannot go to jail. Yes or no? It cannot practice medicine or become a CA or a CS or a CMA. Yes, it cannot do things which are very personal or they require personal skill. Okay, there are few extra points which I want you to know. See, yes, LLP is an artificial legal person, it is separate, but I think you will also agree with me when I say that LLP is invisible. Can you see LLP? I'm telling it is a separate person. Where is it? Where is it? You can't see LLP. It is also intangible. You cannot see it, you cannot feel it. It has no physical existence. You cannot see it, you cannot feel it. Yes, so it's invisible, it is intangible, but can I say that it is immortal? Okay, now what is the meaning of mortal? Mortal means person will die someday. Immortal means person will live forever. So LLP doesn't die naturally. It continues to exist till it is wound up. It can be wound up only by operation of law. So it is immortal. Okay, it is immortal means it does not die naturally. It must be wound up by operation of law. There is a process which you need to follow because see, it comes into existence by operation of law. So you also have to wind it up by the operation of law. However, we can rightly say that it is not fictitious. What is the meaning of fictitious? Fictitious means it does not exist. No, 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 no. We can't say that. It is not fictitious. It is not imaginary. LLP does exist. You can't see it, you can't feel it, but it does exist. Okay, so it's not fictitious. What is the meaning of fictitious? Fictitious means it does not exist. No, no, no. LLP does exist. It has a common seal also. Now, common seal. See, if LLP is a separate person capable of contracting, you will have to affix some signature on the contracts. Yes. So you can write that LLP is capable of contracting in its own name. Yes, you are capable of contracting in your own name. If you are contracting, you need to sign documents, agreements. How will it sign? It's an artificial person. So the signature is known as common seal. So common seal is actually the signature of LLP. But it's not mandatory, okay? It's not mandatory. See, there was a time when when common seal had relevance. Now, what is the story behind this? Why is it not mandatory? In the earlier medieval times, the kings were mostly illiterate because they were so busy learning how to fight a war. They did not know to read, they did not know to write. They signed the documents by pressing their fingering, and the impression was considered as their signature. But we are living in modern times. People know how to sign, people know how to read and write. So this common seal has actually lost its relevance. It's like, reminiscing the medieval times. So because LLP is capable of contracting in its own name, it can enter into contracts. And because you're entering into contracts, you need to sign. Why do you need a common seal nowadays when everybody knows how to sign? So LLP, the common seal is considered a signature of LLP, but it's not mandatory. But I want to have one common seal. So in case you decide to have one, there are two requirements. Okay, it's not mandatory. However, in case LLP decides to have a common seal, then there are two requirements. The first requirement is that the common seal must be kept in the custody of some reasonable or reliable official. Whenever you affix it, it must be in the presence of at least two designated partners. Otherwise, if it is not, if the designated partners are not mentioned, we will never be able to keep a track on how the common seal is used. So it has to be kept in the custody, because see, common seal is signature of LLP. If you wrongly affix it, it is like LLP is liable. So because it is like the signature of the LLP, the seal shall remain in the custody of a reliable official, somebody whom you can trust. And if you are affixing it, it must be affixed in the presence of at least two designated partners. So yes, it is not compulsory, but in case you choose to have one, then there are two requirements. Alright, so this was all about LLP. Next, let us discuss LLP agreement. LLP agreement basically provides for the mutual rights, duties of partners among themselves, LLP and partners. We had discussed that agreement must be in writing. We had discussed about LLP agreement. It provides the mutual rights and duties of partners, LLP and partners. What if there is no LLP agreement? Then what will happen? Yes, in that case, we will follow the first schedule. You don't have any LLP agreement, then you follow the first schedule. So that was about LLP agreement. Next, we have no mutual agency. This is very important. See, in case of traditional partnership, the partner was considered as principal as well as agent. So each partner could bind the firm as well as the other partners by his own acts. But in case of LLP, the partner directly binds the LLP, not the other partner. So I am liable only for my act. I am not liable for the individual or the unauthorized acts or misconduct of the other partner. Ma'am, if you are not liable, then who is liable? LLP will be liable. LLP will, they will pay, and then they will recover it from that defaulting partner. But I am not liable. My liability is restricted only to the extent of my capital contribution. So in case of, you can write down in case of. So we can divide the discussion in two parts. In case of traditional partnership, and then we can compare it with LLP. So in case of traditional partnership, each partner can bind the firm as well as the other partner by his act. So each partner can bind the firm as well as other partners by his acts. So can I say that each partner is bound as well as he can bind? He is bound as well as he can bind. He is principal as well as agent. So as a principal, he is bound by act of other partners. What is the meaning of bound by the act of other partners? X, Y, Z, they are partners. Z took loan of 1000 from A for the firm. If he is not able to pay, X will be bound. What if X purchased goods of 10,000? If he is not able to pay, then Y and Z will be liable. So he can bind. If he is bound, he's acting as the principal. If he can bind, then he's agent. So a person plays double role. He's principal as well as agent. I can bind not only the firm but also partners. But in case of LLP, each partner can bind only LLP by his acts, not the other partners. Okay, I can bind only the LLP by my acts, not the other partner. Okay, so this is one of the main differences. I will just say it to you because it is already printed in your textbook that partner will not be, I am not liable for any individual or unauthorized act of the other partner or the misconduct of the other partner. Ma'am, this is about independent and unauthorized. It means he was not allowed to do so, but he did that. What about authorized acts? Will you be liable? For that, LLP is liable, no? So indirectly, my share is also liable, no? But unauthorized act, I am not liable. Liability is limited. That is the 10th characteristic. Let us discuss about minimum and maximum number of partners. How many minimum partners required? So we need at least 2. Maximum, there is no limit. Now, from these only, we will require at least 2 designated partners. These generally look after the legal compliances, filing of returns, documents, communication with the ROC. So at least 2 designated partners. Out of these out of these, at least 1 designated partner must be a resident in India. What is the meaning of resident? Resident means he must stay in India for at least 120 days during the financial year. Okay, 120 days during the financial year. Now, let's say that I have 4 partners. I need at least 2 designated partner. From whom? From these 4 only. The designated partner will be from regular partners only. So you are a regular partner, you are also designated partner. So I need at least 2 designated partners and they will be from among the regular partners only. So out of these 4, any 2 will also be the designated partner. So I need at least 2 designated partners. Out of these, at least 1 should be resident in India. You should be in India. If something goes wrong, we should find someone to communicate. At least 1 person should be in India so that we can hold him responsible. We can communicate with him easily why these returns are not filed, etc. We are going to discuss about this in detail in my next session. But for now, this much is sufficient. I hope you wrote everything. Let us now read it from the textbook. We have taken down beautiful notes. So let's highlight the keywords. Now, LLP is a body corporate. What is the meaning of body corporate? Body corporate means that it is separate legal entity from its members. It is capable of entering into contracts, holding property in its own name. That is separate legal status. Formation is also very simple. Only 2 persons carrying on profitable business, they can subscribe to the memorandum. Is your partnership agreement. There is nothing but partnership agreement. You have to file everything with the ROC at the time of incorporation. All changes in the deed agreement should also be communicated to the ROC. You can start a business in LLP only if it is made with the intention of earning profit. So your business must be lawful with the aim, with the intention, with the view of earning profit. LLP cannot be formed for charitable or non-economic purpose. It enjoys perpetual succession. Death, insolvency, retirement, insanity of the partner has no impact on the existence of LLP. It is a separate person in the eyes of law. Creditors of LLP will be creditors of LLP only. It also has limited liability. Liability of partners. Okay, we are not discussing about liability of LLP. We are discussing whenever liability is used, it is always of partners. Even in case of company, whenever you talk about liability, it's always of members, because company's liability is always unlimited. LLP's liability is always unlimited. Whenever we talk about liability, it is the partner's liability that we are talking about. So liability of partner is limited to the extent of their capital contribution. This contribution may consist of either tangible or intangible or assets of both nature. It's an artificial person. It is created by law. It is clothed with all the rights of individual. It can perform all the acts like a natural person. It is, however, invisible, intangible, immortal. But it is not fictitious, that we discussed. It has its own common seal. If you want to have one, then there are two requirements. The first requirement is that it must remain in the custody of some responsible official. Okay, some responsible, reliable official, and it can be affixed only in the presence of at least two designated partners. LLP agreement must be in writing. It discloses the mutual rights and duties of partners within LLP. If there is no agreement, then you follow Schedule 1. There is no mutual agency. No partner will be liable on account of independent or unauthorized acts of the other partners or their misconduct. All partners are agent of LLP. No partner can bind other partner by his acts. We need minimum 2 partners. We will also have at least 2 designated partners. One should be resident in India. Maximum, there is no limit. Management is in the hand of the partners only. But yes, we have designated partners for legal compliances. Accounts should be maintained annually every year, and they should also be audited. These are self-explanatory points. That is why we have not made a note of it. You will study directly from the textbook. E-filing of documents on MCA's website. It must be authenticated. It must be signed digitally by partner or designated partner using digital signature. We have studied that in Companies Act. Compromise or arrangement including merger and amalgamation will be in accordance with the Act. You can convert firm to LLP, private company to LLP, unlisted public company to LLP. This is Schedule 2, this is Schedule 3, Schedule 4. For an LLP, it is incorporated outside India, but it is having a place of business in India. It is a body corporate. Yes, it is a body corporate. That is why it can become a partner in Indian LLP. It's a body corporate capable of contracting. Indian Partnership Act does not apply to LLP. Very simple after we took notes. I would also like to discuss advantages with you. Advantages, a very small part can be, I don't think it will be asked, but there is always a comparison between LLP, partnership and company. So LLP is more organized than partnership. It is more flexible than a company. Formation is easier than company. Liability is limited as compared to partnership where it is joint several unlimited. Dissolution is easier. Okay, it is easier than company. So it is, let's say, easier. So it is more organized than partnership. It is more flexible than company. Formation is easier than company. Liability is limited, and dissolution is also easier as compared to the company. Procedures are less. So students, with this we come to an end of advantages. In my next session, I will discuss partners and designated partners in detail with again handwritten notes. I'll see you there.